Today we're going to talk about what actually happens at a Merit Systems Protection Board whistleblower hearing. Merit Systems Protection Board, otherwise known as the MSPB, and I'm talking to all the people out there who have an MSPB case or are considering becoming a whistleblower. Their case is with the OSC right now, and they're curious what actually happens at these hearings. So here's the story. They are mini courtrooms. They're not real courtrooms. A lot of them are nothing more than conference rooms. The judge may be in person. Most of the time, the judge is by video. The appellant, the employee, who I always represent at MSPB hearings, sits on one side of the room with me. On the other side of the room is the agency lawyer. There's a witness chair, and it has a court reporter and videographer and so on and so forth. So you may recall, and I write a chapter about this in one of my books, that the whistleblower cases at the MSPB are distilled into three distinct elements. The first, what is a whistleblower? There must be a disclosure, a whistleblower disclosure, meaning somebody actually has to complain about something in good faith, something that evidences a violation of law, rule, or regulation, or shows gross mismanagement, or an abuse of authority, or a substantial and specific danger to the public health or safety. So generally speaking, the first part of the case is going to be the appellant testifying, not always, but the appellant has to establish that he or she made this actual disclosure. The second part of the hearing has to do with, was there a contributing factor to the adverse action that the agency did to the person after he or she made the disclosure? And usually what the courts have said is that if the action that happened against the employee took place within a year of when that person made the disclosure by the people who were aware of the disclosure, who the disclosure was against, that will satisfy the contributing factor part of the three-part test. So we've got the disclosure, the contributing factor, and then finally there's the clear and convincing part of the case, the third element. The agency has the burden of proof, not the appellant. This is not like EEOC discrimination cases, where the plaintiff there has the burden to disprove the agency. That's not what this is. Here, once the first two hurdles are met, the burden is on the agency, and it's a high burden to show by clear and convincing evidence that they would have taken the same action anyway against the employee. So for example, someone is getting suspended and the appellant contends the reason for my suspension is because I blew the whistle on a violation of law or gross mismanagement. And the agency contends, no, we would have suspended you anyway because you were a louse, you were mean to people, you sexually harassed someone, whatever the reason, we were going to do that anyway. Okay, now you have to understand how these judges work. And I'm not trying to be cynical here, okay? There are some good MSPB judges. There are many bad ones, but there are some good ones. And it's like any other group of people. You're going to find people who excel at what they do. You're going to find many people who are lousy at what they do. I once had a coach who taught me that guy was a former agent with the Israeli Mossad. And he said one of the keys of how the brain works is the brain is always trying to conserve energy. The brain is always trying to look for shortcuts to solve problems. That's just the nature of people. MSPB judges, many of them are no different. So here's what the point of the hearing for the MSPB judge is. the MSPB judge is thinking to himself, if I can knock out this case on disclosure, if I can get the appellant to admit, that his disclosure does not meet one of the strict definitions of what the disclosure has to be, the case is over, and I don't have to do any other analysis. And when you've got several hundred cases that you've got to go through, this is the way the MSPB administrative judge brain works. How do I conserve energy? Simply by wiping out the disclosure. Now, each of these categories of disclosures has a definition. For example, gross mismanagement means a management action or inaction that creates a substantial risk of significant adverse impact on the agency's ability to accomplish its mission. Or waste of public funds has a definition, which is more than debatable, that the expenditure is significantly out of proportion with the benefit reasonably expected to accrue to the government. So think of it this way. Let's say somebody makes a claim, and by the way, here's another way they save a lot of time on these cases. If your disclosure was not in writing, most of the time, the overwhelming majority of the time, you will lose on actual disclosure, because there's case law that says that if there's no evidence of the written disclosure, then the AJ is limited in how he can rule for the appellant. So you always want to put your complaints, your whistleblower complaints, in writing. Another thing you want to do is, if you're thinking about issuing a whistleblower complaint, you always want to hire a lawyer who has done MSPB cases, is familiar with the process, to help you write the whistleblower disclosure. Because if you do this without an attorney, and you don't do it correctly, and you don't do it in a way that meets one of these definitions, the current state of the law is that you will lose. And it doesn't matter how bad the conduct was on the other side. It doesn't matter what the government did. Once the MSPB judge finds that you, the employee, did not meet the disclosure rule, did not meet that definition. And here's another thing. It doesn't matter what you thought the problem was. If you thought the problem, let's say that there was some E. coli outbreak somewhere in Kansas, and you're working at the USDA, and that this could really affect the lives of thousands of people, it doesn't go by what you thought. It goes by what you actually put in the disclosure. Your disclosure had to say something along those lines. It couldn't simply say, hey, there may be an issue with E. coli. So you always want to hire an attorney to draft those emails, those letters, those complaints, so that they meet these definitions. Now, here's what happens at the hearing. Every single hearing goes exactly the same way, because I've done a gazillion of these. Well, maybe not a gazillion, but enough of them. The appellant testifies. The appellant shows his hand. He shows the emails he wrote, he shows the letters, and he explains what these things are about. For example, there might be an issue an appellant had about favoritism by a supervisor, of wasting government funds by buying certain gear for one employee over another. And that was a concern to the appellant. The employee said, hey, this is going to ruin the cohesiveness of the unit. This is an inappropriate relationship that these two have. And there is some issue with that. I mean, it's not like that's certainly nepotism and favoritism, and this is what we're trying to prevent in the federal government. So he goes through his disclosures. Usually this takes around 45 minutes to an hour. In almost all cases, there will be a cross-examination by an agency lawyer. who, God bless these people, a lot of them have a lot of good souls, but let's face it, they've never done jury trials. They've never really been challenged in any serious litigation. So essentially, they just don't have the skills to give anything more than a 15 or 20-minute cross-examination. They try to get some of the points out, try to undermine the disclosure, but they usually don't do a good job. And again, there are some excellent agency lawyers that I've litigated against. This is not true of every single one. I don't put all of these people in the same category. There are many professional ones. There are some that have done a lot of good jury work and have been in complicated litigations. The fact is, most of them have not. So after this softball cross-examination, you think you're done, and you think, great. Now my guy gets off the stage. Next witness, they're all agency witnesses. I'm going to beat the hell out of these people and win. Wow, this is easy. Not quite. That's not what happens. What happens is the AJ, the judge, the gatekeeper, he or she will now cross-examine your client, the appellant, in some cases for well over an hour. I've had this. And at the end of the day, what is this AJ trying to do? This AJ is trying to get the appellant to admit that really his disclosure didn't meet the definition of gross mismanagement or waste of public funds or abuse of authority, or this really wasn't a danger substantial to the health or safety of the public, or at the end of the day, the employee was only guessing. The employee really didn't cite any violation of law. The employee was just bitter. The employee was upset, and he raised this issue. And what happens is, after the employee is intimidated by the AJ, the employee has been subjected to this brutal cross-examination by the judge in a robe, asking a lot of leading questions, some in a mean way, some in a disparaging, sarcastic way, all to get those admissions. And at the end of the day, once that's done, the AJ snoozes for the rest of the case. He may take some notes on the rest of the case, not many, because the rest of the case isn't really going to matter. And then the AJ ends up writing an opinion that says, yeah, sorry, guy, you really didn't have any actual disclosures. And therefore, I don't even get to what the agency did. It didn't even matter. You lose. Now, obviously, there are a number of ways. I mean, we're not going to, at my office, we're not going to just walk in there and have this happen. I mean, there's game planning around this. You know, we kind of know this is what the case is going to be. And the best advice that I can give is putting the perceived whistleblower strategy aside, for which probably is really for another podcast, because that's pretty complicated. The appellant has to really understand these definitions and not just be able to recite them. That doesn't really do it. The appellant has to understand, the employee has to understand why his disclosure would be protected. And the employee has to understand what the process is and how to protect against the leading, intimidating cross-examination questions which would undermine his or her case. And as I said earlier in the podcast, the real key is to retain an attorney before you complain. That is the best way of protecting yourself. Because if those disclosures really meet those definitions, and then you get retaliated against, which happens all the time at federal agencies, you will have an excellent chance of prevailing, or the government will settle your case. Earlier this year, we settled a case out in Colorado, and it was an MSPB case. The case never went to trial. The appellant had done everything we told him to do. The appellant was on the ball. The appellant the appellant was masterful at deposition. The appellant defended himself really, really well, and the agency had no choice but to settle. Now, there is one other way that an appellant can still win his case even if that federal employee did not put his disclosures in writing. And a lot of people don't know this, but there's a doctrine called perceived whistleblower, which means the following. Now, you have to plead this from the beginning of your case. You can't just come up with it at the hearing. What you've got to argue, or the issue you've got to raise, is that even, Judge, if my disclosure did not meet the strict definition of actual disclosure, if the agency supervisor who retaliated against me perceived that my disclosure did meet that definition, then it doesn't matter that you beat the hell out of me on your cross-examination, because the case still continues depending on what the agency witnesses say. Now, watch out for one of my future podcasts in which I'm going to talk about how one can become a perceived whistleblower. But I'll say this about it. It's pretty tricky, and I'm not going to put a lot of trade secrets into it. It's really for clients because it's a powerful weapon for winning. If you believe you are a victim of whistleblower retaliation or you are in a whistleblower situation, call now. We would love to help you.